I'm David Glazer.
And I'm Katie Yelton.
And we're here to participate in what I guess we're calling the Winter Health Law Olympics. We're going to race to see how many questions we can answer over the course of the next hour. Before we dive into the questions, just a couple of announcements. So first, let's say you wanted to ask a question today. How do you do it? So it's actually a little more obtuse now because of this full screen mode. Take your mouse up, if you can see what I'm doing here. You hover over in the middle, a little bar will pop down. And on one of the options on that bar is chat away. You'll send the question to Robert, who can print it off in that noise that sounds kind of like an airplane taking off, and we will try to answer them. Second, our next webinar, which is on April 9th, will be by Katie Douglas and Ryan Johnson. They're going to talk about joint ventures and kind of from the perspective of both hospitals and clinics. How do you do joint ventures and the like? The May webinar, which is May 14th, Jim Platt and Gail Brandt are going to talk about physician compensation and related issues. And the only other announcement, well, we have two more announcements, but one of them is, you remember the internet occasionally slows down over the noon hour. Everyone's checking the Olympic scores. If that happens to you, you can dial in the number Robert is typing in the box. So before we get into the questions, we were lucky enough to pick up a new colleague recently. John Kapasinskis joined us, and John's been doing this a little bit longer than I have, just a little bit longer, but I'll tease him about it nonetheless. So he's been doing this for like over 20 years, and he's an Iowan, which I also could tease him about, but I won't. I know you practiced in Texas for quite a while.
Correct.
And so when John was there, he worked for a couple of large health systems down there, or represented them. He was an outside lawyer for some large health systems, including a clinic-based system and then a large academic medical center, a medical school type thing. And then you moved back up here a few years ago. So, what sort of stuff keeps you busy, John?
Thanks, David. The best way to describe my practice would be to say that I provide operational advice on compliance with state and federal laws and handle governmental investigations and lawsuits on behalf of healthcare providers. And some examples of the things that I've handled would be a governmental investigation with regard to counterfeit spinal implants. I helped our client with the investigation and guided the hospital system in its response and possible recall of devices. I also was involved in a NICU heparin overdose matter where I assisted the client with the investigation, the pharmacy formulary, and dealt with the state investigation and malpractice claims that were related to the exposure. I also represent healthcare providers in commercial contract disputes, such as breach of administrative service agreements, software agreements, and equipment purchases. And I've been involved in a number of malpractice cases over the years, birth trauma, VBAC cases, vulnerable adult cases, and surgical equipment failure, sort of when there is a wrinkle in the case where there is a dispute between the healthcare provider and the manufacturer of the device. I help the healthcare provider through those types of claims. I've also been involved in board complaints and physician peer review and credentialing matters. Sort of the sort of waterfront of healthcare litigation. I think the main way you would describe it is that I help healthcare providers resolve disputes that arise in the course of their providing patient care.
Well, thanks, John. We are excited to have John. Our gang of health law litigators continues to grow, and I know I'm certainly excited that John is part of it. So we are now, I think, prepared to dive into a fleet of questions. And so Katie and I are going to have this contest here to see who can answer the most questions over the course of the next hour.
We're really into contests because David and I are both big dorks and love the Olympics, and we're frankly sad that they're over. So
yeah,
here we go.
Although, you know what? Actually, my son is still watching some of the Olympics that he DVR'd, so I'm still living them.
Oh, lucky. All right, so our first question. Get the slide here. All right, David, are coders personally liable?
We get this one a lot, and it's often coders have gone to some conference and been told that they need to buy coding insurance. And coders are almost never personally liable. In fact, the reality is, in an organization, individuals are almost never personally liable for stuff unless they did it themselves, like if you're embezzling or something. And so state law and corporate documents control here. Most states, not all, but most have indemnification provisions that say an employee is can turn to their employer for reimbursement for all expenses they incur if the employee acted in good faith, thought their conduct was legal, and believed that they were acting in the company's interests. So from a coder standpoint, I know of one coder in the country that's ever gotten into big trouble, and that was in California, and it was a coder who was watering down chemotherapy drugs as part of a really icky scheme in a clinic. Coders don't need to worry about this, but that anxiety, I think, is a big issue, and I think an important thing to do is to get everyone in the organization understanding that there's organizational risk, but not personal risk. And the reason that's important is that people sometimes, when they think they have personal risk, get a little panicky and do crazy things. So, Katie, do the Medicare Advantage rules apply, or sorry, do Medicare rules apply to Medicare Advantage patients?
A very good question that has been puzzling us for a number of years. So I can tell you this. There's no rule that expressly states that your traditional Medicare rules apply to Medicare Advantage patients. So there's no rule saying as such. And when you try to figure it out and you call Medicare and ask them the question, they say, oh, you'll have to ask the Medicare Advantage program. And then you call Medicare Advantage and they say, oh, you have to ask the Medicare program. So that's happened on one or more occasions. So there's nothing in the regulation or law that says, the Medicare rules apply to Medicare Advantage. But what you should do, however, is review your payer agreement very carefully, and don't forget about the provider manual for that particular payer, because the payer agreements loop in provider manuals as rules that govern you, that you've agreed to as your contract. And you might find in the provider manual some language expressly saying some other rules apply. So it's very important to read those two things.
And I'm just going to chime in and say that, Katie, I researched this really hard for a client of ours, and I was really impressed with the result, and she drilled down on this one. We're confident on this one.
I will say think about Stark differently. Stark falls in the sort of Medicare rules section of the CFR, but the Stark statute is clear that Part C, at least the statute says Stark applies to Part C. So if you're
Part C is Medicare Advantage.
Right, Part C is Medicare Advantage. So if you're doing a Stark analysis, and Stark has big penalties if you're not complying. So I would consider Medicare Advantage as part of the mix when you're talking about Stark. All right. David, can we charge interest on outstanding balances?
Well, I would say yes. Well, let's hang on. Put an asterisk there. And as is often the case, your payer contracts and state law can affect this. So first asterisk, that applies to really almost everything we talk about that's not Medicare specific. And so it's always good when we forget to say, don't forget state law and your provider contracts, to think about that. Medicare says that the answer is no. And I am quite convinced that Medicare's claim is wrong. And this is, I think, we've got the most slides on this particular question. Medicare points to the regulation that says that basically you can only charge the allowed amount and then any copayment and deductible. Okay, so Medicare points to this. The problem, what Medicare is ignoring, is a Medicare Learning Network, MM5613, which talks about charging for missed appointments. And you'll see, what does this have to do with interest? But we'll see in a second. Medicare explains that when you charge someone for a missed appointment, you're not charging for the service, but you're charging for a missed business opportunity. Well, when you charge interest on someone who hasn't paid your claim, you're not charging them for the service, you're charging them for the lost business opportunity. It's exactly the same. So I had a client get a snarky letter from CMS telling them that they were going to get in big trouble for having charged interest, and I wrote back and pointed this out. And that was the last I ever heard from CMS. And, CMS can sometimes be slow to respond to you, but I think we're on 4 years now. So I'm thinking they're not feeling super confident in that position. Now, there's a related question that comes up a lot. Oh, actually, hang on. I should just also mention, if you are going to charge interest, you have to know things like how much you're charging. And, there's a Federal Truth in Lending Act that can require you to have a written agreement when you do this sort of thing. If you're extending credit, there are requirements there. You got to know your state usury laws. Most states will let you charge a small amount without a written agreement, but not all. Minnesota is 6%. I think Georgia is 6%. Some states go up to 8%. So you just have to know about that kind of stuff. A related question we get a lot is, can you give free transportation to patients? We're gonna have this theme of free stuff coming up here for a bit.
All right, so the free transportation question. There's no clear answer, and what we have to guide us are the OIG's advisory opinions. Now, those opinions apply just to the parties who asked for them, but that's what we have. And they cover federal anti-kickback and CMP concerns. However, you can't necessarily just give free transportation to private pay patients because you might have state laws that say that's a kickback as well. So think about them kind of as a group. So what the OIG has said is that we're not going to say free transportation is okay across the board, but in certain arrangements, we think there are factors that make it less susceptible to fraud risk. And I've listed those factors here, so I won't go through them. And I will also say, just having one of these factors I would try to have as many of these facts as possible, because the more you have here, the more boxes you check here, the better your free transportation program will look to the OIG. Some general takeaways from those OIG opinions, of which there have been probably about 12 over the past 15 years. On campus, between sites on campus, free transportation is usually okay. The OIG views that as low risk. Long distance, like plane rides, are usually blessed only in very rare circumstances and, extenuating medical issues and rare situations. The big question we get is, what about in the middle? What if you have sites that are miles apart that aren't really considered the same campus, but it's within the system? And David and I think that it's if you consider if you have transportation going within the system and you've also mitigated it with those other factors that I mentioned, we think there's a pretty good argument that you say this transportation is part of the system. It's not an additional piece of value to the patient that's a kickback. However, we do feel like transportation to and from patients' homes is riskier. There is one advisory opinion that says that the OIG wouldn't take issue with the arrangement, but they had all of the good factors, and that was from a long time ago. So I'd stay away from picking up people from their homes.
And so one thing that we've kicked around a little is an interesting question. What's the illegal thing is giving someone something of value. And so an argument that we've explored is the thing something of value? There is an argument, I think, to be made when you're doing something that levels the playing field, and this is going a little afield from free transportation, but it's come up sometimes like in the transplant context. Can you provide someone with a place to live, for example? And I would try to argue that it isn't a payment that incents someone to come to a particular place. And what I mean by that is, if you're a patient and you're choosing between place A close to home and place B far away, if place B far away offers you a place to live, that doesn't make you more likely to choose place B, because the place to live just levels the playing field in your choice with place A. This is not a perfect argument, because there's another federal law out there about basically anything that could influence a referral, but it's just something to think about. It's something we've kicked around.
David, can we give free care to Medicare recipients?
So this is an interesting question, and I think people are often quick to say no, because there's stuff that says you can't waive copays. There are all kinds of times where it's okay to give free care to Medicare recipients. So I'm going to go with a couple of examples. This is one. So someone asked in particular, hey, our hospital makes you do an EKG before someone's scheduled for surgery, but Medicare usually denies it. And if that happens, we write it off. Can we do it? And I would say, yes, you can write that off. And the reason I feel really comfortable with that is if Medicare is saying it's not covered, they're saying we don't think it's medically necessary. And I think it's hard for someone to say that there's value there, because that's Medicare's whole point in denying is we think it's not necessary and of no value. So I'm just not going to be stressed about that at all. If the patient is poor, I'm not worried about writing off their thing. And if they're angry about something, I'm not writing it off. So what you can't do is give free care to someone that's intended to influence referrals. And that's not what we're talking about here. So it depends on your why, but in those examples, I'd be totally kosher with it. Now, medical records are going to come up in a bunch of the questions. So Katie, one thing I hear all the time, I've heard this for 20 years. I get medical records from an outside clinic. We're a clinic, we're a hospital. We got these records from another clinic. We can't release them because they're not our records, right?
Actually, contrary to popular belief, there's nothing in HIPAA that says you can't release medical information from a third party. And in fact, the patient has a right to receive that information if they ask for it, and you can disclose it to other parties in in compliance with HIPAA. And that's because PHI under HIPAA is any health information that is created, maintained, or received by a covered entity. So if you received medical records from an outside party, it's part of your designated record set under PHI, and you can do with it what you can do with other PHI under HIPAA. Now, there is a big exception to alcohol and drug abuse records that are very specially protected under a different part of the federal regulations. And those are it's very hard to redisclose those. And they should come with a big stamp on them that says federal law prohibits you from redisclosing these records. But even if they don't, be aware that if you have alcohol and drug abuse records from a chemical dependency treatment center, that those can only be redisclosed under very specific circumstances. I suppose it's possible there are other state laws out there that could prohibit you from redisclosing records. I think in Minnesota we have one of the strictest health records laws, and we don't actually see this being a limit, but it's possible that could be out there. All right, David, can we give prompt pay discounts?
Prompt pay discounts make me a bit nervous, actually, from a pure legal standpoint. And so one of the questions is, why are you doing it? I've heard a lot of places say we're going to give a prompt pay discount because we don't have to bill. Like if they pay at the time of service, we don't have to bill them. One thing to keep in mind is many payer contracts prohibit what you'd call a billing fee. And so if you pay at the time of service, we don't have to bill you, that makes our fee cheaper. That suggests that there is a billing fee for everybody else. So I'm not loving that. Another potential issue is, could someone characterize 5% for paying on the day of service as charging a 5% or usurious interest rate for a one-day loan? And the answer is yes. Now, that said, I love my dentist. Why? Because they give me a 5% same-day cash discount. And I don't complain about it. I take the 5% and run. So I think people do it. I think the legalities of it aren't really perfectly ideal. I'm going to sneak in. We're getting questions are kind of pouring in right now, and I'm going to sneak one in here that's kind of fits to this, which is, what about a rebilling fee? Is a rebilling fee interest? And I think a rebilling fee is not probably interest. I think you've got a decent argument that it's a different animal. I know this. I wouldn't want to do it without making things really clear to the patient, first of all. I think that you're asking for a giant headache on that one, and you better read your payer contracts really closely. So I think you're more likely to run afoul of that sort of thing. I don't think that that's likely to be characterized as interest. So, Katie, we're back to HIPAA, since you know so much more about HIPAA than I do. So I wasn't careful. We've got a bunch of envelopes, a bunch of letters were one off. Everyone got one. So I got your letter. Is that a breach?
This happens a lot. And I kind of hate answering this question now, because I think that under the old breach definition, before it changed in last September, I think you had an argument based on depending on the facts, that you could say it wasn't a breach because breach used to be there had to be a significant risk of financial or reputational harm. And so if it was just sort of a plain vanilla letter with not a lot of information in it that just went to the wrong person, I could get comfortable with saying it probably wasn't a significant risk of a reputational harm. Again, depending on what's in the letter. That's always going to be a factor. However, now the breach definition, although OCR said we're not really changing this, they changed it. The breach, it's now everything is presumed to be a breach. Any HIPAA violation is presumed to be a breach. So you're starting out with the breach, and then you have to sort of disprove it. And the test is whether the information in the letters is, I'm not going to win the grammar Olympics here. It should say is probably compromised if someone opens it. Well, if someone sees it, the information's compromised because it doesn't go to the right person. So I think it's harder to get to my it's okay answer under the new breach definition. I think before it mattered if it was the mayor's information, and now I think it's probably compromised if someone opened the letter and there's PHI in it. So I hate to say it, but I think you got to look at it more closely. All right. David, I got some really good legal advice from you. We already know this is fiction. Can I send this to my colleague over at the other clinic?
Well, you can, and it's interesting. So sharing legal advice comes with some issues. And this is one of those answers that's really self-serving for us lawyer types. But when you share information that you've gotten from your lawyer, you're almost certainly waiving the privilege. The possible exception to that, so which doesn't mean you can't do it, it just means that the advice you got from the lawyer is now discoverable. And then one of the questions is, how broad is that waiver? Does that mean that the government could look at every piece of advice you ever got from me as your lawyer? Or does it mean the most likely thing is on that subject, all the advice on that subject, although how is that subject defined? Is it Medicare billing or incident to, that kind of stuff? Now, there's one exception where you sometimes can share advice, and that's the common interest privilege. And this can come up, so let's say, a hospital and clinic are in some sort of negotiation. The communication between the two sides is not privileged. I mean, even if the lawyers are going back and forth, they're opposite sides. There's no privilege there. But there's a belief that you might be able, if the two sides have a common interest in getting advice, share that information and claim it's protected under the common interest privilege. That's an evolving area, and there's not certainty. So basically, share information at your own peril.
I will say, I see this a lot, and I know people don't mean to do it, but I will send a client an email with some tips on a contract that they want me to review, and I'll send my thoughts back, and I'll say, here are my comments to you. This is a bad clause, and you should ask for this, and all of this. And then, a couple weeks later, I'll get the email back from the client saying, this is what the other side said, and I'll see my email at the bottom of the chain. And that was the email that I sent to the client. And so I think you've probably blown your negotiating position if you're talking about your strategy and you're showing it to the other side, but you've also probably waived the privilege in that instance. And so be careful about, emails are crazy and we all experience that, but be careful about making sure what you forward isn't actually the legal advice.
Speaking of email, I feel like I should ask this next question in code. So Katie, does HIPAA require us to encrypt our PHI?
All right. So the HIPAA security rule says that encryption is addressable. That is, it's not required. So what the heck does addressable mean? Well, that basically means that if you're not going to, you have to figure out whether it's reasonable to have encryption for your organization. And if you conclude that it's not reasonable or appropriate, you have to say you did so and why. Now, encryption is becoming, it's OCR, the agency that enforces HIPAA, highly favors encryption. People are using encryption more and more, and so the industry is going to determine what's reasonable. And if you're a big system with the government perceives you have a lot of money, it's going to be hard to say that encryption isn't reasonable for you. So it's still addressable, but everyone's moving toward encryption. And absolutely, if you have laptops and devices that are storing PHI, encrypt them. If you are sending PHI that is outside of a virtual private network or some other secured method, I think you should encrypt them, because it's the first thing a OCR surveyor is going to look at, and you're going to sit there and argue about whether it was reasonable. And you don't really want to argue with these people. So I think, eventually people are getting to encryption, and it's the way to go. There's this weird thing about email encryption, and I'm not a tech person, but depending on the sort of abilities of your encryption software, you could still, I think, send an encrypted email that was protected in the transmission to the wrong person. And if you don't have a good mechanism in your software for making sure that only the right person opens that email, then you could still end up with a breach. So think about that as you're looking at your vendors and talking to them about sending email via encrypted methods, because that's a piece you don't want to forget about. David, can physicians get credit for ordering ancillaries?
So this is a question that, it's now 20 years old or something close to it. And the short answer is you can't get credit for ordering an ancillary that's a designated health service under Stark, which means if it's a Medicare or Medicaid patient, no. Now, under Stark, you could get credit even for designated health services to non-Medicare and Medicaid patients. And actually, Medicaid's got question marks. We'll come to that in our next question, or in my next question. But this is a place where I don't want to push the line. I think it's too risky, and the penalties with Stark are so draconian. I am not a fan of giving credit for ancillaries, but legally, you can give credit for ordering X-rays to non-Medicare and Medicaid patients. Stark doesn't apply to private payers, so you don't have to do with that. So what can you do from a practical level in your comp formula or something like that? Well, if you've got money from your MRIs, you can divide it evenly. You can divide it on RVU production. You can divide it on some combination of things. Like you can do 20% evenly and 20% on RVU production. What you want to steer clear of is on dividing it based on who ordered the MRI. And like I said, you could, in theory, legally carve out Medicare and Medicaid and divide it based on who ordered private pay MRIs, as long as you are in a state that allows that. And some states have laws that extend Stark, Florida, New Jersey, and the like. So, and actually, this may be as good a place to any as just chime in and say, by the way, there's another move afoot to repeal the in-office ancillary exception. It's in the Obama budget. I believe it was in the Obama budget last year.
Yep, I think that's right. It's it's pretty early to tell, too early to tell.
So just FYI, it's out there. So Katie, emails. Can I send an email to a patient?
So the law does not prevent you from sending emails to patients. Just a lot of other considerations when doing so. The first would be, HIPAA. So HIPAA, let's talk about, there's kind of two buckets here. The first is if a patient is asking for an electronic copy of their PHI. This is specifically covered by HIPAA, and now they can get an electronic version of it. And the commentary to this last rule talked about, well, do you have to send it in an encrypted email? And the rule is you can only send it in an unencrypted email to the patient. This is their record set. If you talk to them about the risks about receiving an unencrypted email, and they say, okay, whatever, despite the risk, I still want to get it unencrypted. I don't want to deal with all the password stuff. So if that conversation happens, and please document it, because these are the little things that OCR surveyors are going to look at.
Does it have to be a conversation, or can I do it in my intake form in writing?
I think that you could do it in your intake form, so long as you just show the patient was advised of the risks. So good question. So you have a record of that. Then you can send the unencrypted email with the record set. And then sort of the other bucket is just emailing patients generally. And of course that about, their issues or appointments or whatever, that email is going to have PHI. And so I would lean toward, as the industry goes this way, sending email in encrypted manners that contain PHI and making sure you know who you're sending it to. Somebody had asked, what's the industry standard for texting? Kind of fits in here. Again, there's nothing that says you can't text patients. I guess as a risk management piece, I would have a patient say up front in your intake process, I consent to texting. I don't know that I'd, as a physician, really want to text patients a lot. But I think, again, though, the industry, I'm seeing consultants go towards having encryption software for having encryption methods for texting as well. I think we're moving that way. All right. So, David, does Stark cover Medicaid?
So this is a great question. It's a really hard question. And the bottom line is there's some crazy legal arguments that it doesn't. They're not that crazy, actually. There's some text in the preamble that suggests it doesn't. I wouldn't tempt fate, but there's a pretty good argument it doesn't. I want to jump back because we just got a question that kind of goes to my last one. And so the question is, if your production formula only applies to half of your total revenue and your Medicare population is less than 20%, are you okay including ancillaries in the productivity calculation? And the short answer is no, but with a giant asterisk. And the reason I want to talk about this is there's an exception to Stark that at least I often forget to mention, which is if less than 5% of your revenue is from DHS and the pay to each doctor in the clinic, less than 5% of that is from DHS, there's kind of like a carve out. And that can be a catch-all that saves your bacon to be all non-kosher for a moment on this sort of thing. So possibly, but you got to do some real math on that. All right, so Katie, this HIPAA theme just comes up a lot. So do we have to have a business associate agreement with the health plan that we interact with?
Good question. So usually a covered entity, a healthcare provider covered entity, it isn't performing any sort of function on behalf of the health insurer. You're not doing what you're doing on behalf of them. You're providing services to their members, and they're doing their own thing, and they're also a covered entity. And so usually they're not. You're not going to need a business associate with. You're not a business associate of them. However, there is this exception or circumstance when the plan is actually performing a function on your behalf and also on behalf of maybe the plan sponsor. And so you might get a BAA proposed where you're the covered entity. And so you have to figure out what exactly are they doing and try to track that down and then negotiate that BAA accordingly.
So I'm just going to note we're halfway through here, and we're tied, I believe, in the number of questions we've answered. So the race so far is not going so well.
Who knew?
So, Katie, what's our next question?
All right. Can we pay the exchange premium for a patient?
So this is a really interesting question. I've spent a fair amount of time on this one lately. I love this one because I think the answer is pretty clear, and the answer, I think, is yes, you can. The answer is also clear that CMS has said that they don't like the idea. So what we know is that in October, Kathleen Sebelius, in a letter that was clearer than her appearance on Jon Stewart around the same time, said that the anti-kickback law does not apply to the plans. Okay, so paying it isn't a problem under the anti-kickback law. Then, I think November, I want to say 4th, it was either the 4th or the 7th, CMS came out with a question and answer where they said, it's very, very bad for you to do this. Of course, it's very, very bad. If there were a legal reason why you couldn't do it, they would have given a legal reason, and they didn't. They just said it's very, very bad. And they've kind of come out again and tutted a lot. I think insurers are going to hate it, and they're going to try to come up with all kinds of reasons that it's impermissible, but I don't know what those reasons are. I mean, I think I can, employers pay, my premium is paid for by my employer, who argue, is that illegal? No, it's not. So I think this is a bunch of bunk. So I think it's legal. And I've heard some other things I've heard, like the IRS is going to, there were a whole mess of rumors on this. The IRS says you can't do it. Hasn't happened yet. So I think the short answer here is yes, you can. So, Katie, this is a question for which I've been getting another 15 years worth of questions. How often do you have to check the OIG exclusion list?
Okay. So there's no law that requires you to check at this point. I'm shocked, actually. I sort of think it would make everyone's, at least make the uncertainty go away if there was a law that required you to check, but I haven't seen one. And CMS is, changing its opinion all the time on this. Their current position is that you have to check the OIG list monthly. And that comes out of a letter from 2009, I think, to state Medicaid agencies saying, oh, you guys need to tell your providers to check monthly. And then more recently, about a year ago, the Medicare Advantage manual language talks about sponsors having to check monthly. So they push that down to their providers. So that's where that current position is coming from. What about the System for Award Management list? This is the what used to be known as the General Services Administration list, and this is the list of debarments from a lot of other federal agencies. Do you have to check that? Interestingly, CMS I don't think has taken a position on this in terms of telling state Medicaid agencies, like in the letter from 2009. In their manuals for Medicare Advantage, they are telling sponsors to check the SAM list. And so sponsors are pushing that down onto their providers.
And Sam Arbovich upstairs right now is getting very nervous.
Yes. So I guess the answer is know what CMS's current position is, and I think most importantly, know what you're attesting to that you're doing. A lot of ACOs are asking providers and participants to attest to checking these things. So if you're attesting that you're checking monthly, you should be checking monthly.
And for those who don't know who Sam is, Sam Arbovich along with Katie are our nursing home gurus. The two of them know the skilled nursing facility stuff.
All right. David, can I give discounts to non-Medicare patients?
Yes. And the short answer is it just depends, but that's just to be fancy to say if you're giving a doctor a discount because he's in a position to influence referrals or she's in a position to influence referrals, that's bad. Basically, almost anything else, no, I'm still being too simple. But, so let's say they're poor. And so one of the questions we just got, can we create our own charity care policy? Absolutely. Can you give discounts to the poor? Yes. You just need to know what the impacts of things are. So first, for Medicare, if if you're giving a discount to more than half of the patients, well, or let's put it a different way. If more than half of your patients are paying less than Medicare, you are going to screw up your usual and customary charge for purposes of the Medicare calculation, and that's a problem. Medicaid varies state by state. Some follow something akin to Medicare. Some do weird things, like Minnesota uses the mode, which is your most frequently charged rate. And whatever you charge the most, you can't charge Medicaid more. And then private payers have their own gig. So if you give discounts, the real risk is that you're going to permit someone who you're charging more the opportunity to complain about their charge. So for example, if you're charging auto insurers your full freight, and I, walking in off the street, get a 25% discount, the auto insurer is going to go, what the heck, that doesn't make any sense. And they've got a pretty good argument then. So if you're giving a discount, you want to make sure you have a good reason, or otherwise people who are paying more are going to have a legitimate basis to squeak. But if it's for poverty, I'm just not worried about it at all. I've never heard of anyone getting in trouble for giving a discount to a poor person, and I just think that that's zero risk. And similarly, if the patient is mad, I'm okay with it. Although you should know there is this weird statutory provision on Medicare that says if you cover medical expenses for someone, to settle a malpractice situation, if you pay their future medical care, there's like this weird reporting obligation. People don't talk about it much. I'm now going to blank on the statutory provision.
It's a Medicare secondary payer question.
Yes, it's a Medicare secondary payer question, and I can't think of the statute. There's a statutory site for it. It's one of the harder issues I've worked on in my career.
Comes up a lot in clinical trial agreements.
It does. So just as a thing to think about. So on to it now for something completely different. Who are auxiliary personnel for purposes of Medicare's Incident 2 rules?
Okay, so, and just to refresh, so Incident 2 is when, and we're talking about Incident 2 in the office setting, is when you, when the physician is billing for services provided by an auxiliary personnel, and there have to be certain physician supervision requirements, etc. So who can these auxiliary personnel be? The regulations don't actually set many limits on who it can be. In fact, in I think the Halloween 1997 final rule that had lots of excellent stuff that we use, the CMS actually said we're declining to comment on who this has to be, whether it has to be an LPN, etc., because we want to be flexible. So, however, though, as of January 1, there's this new piece to the Incident 2 rules that makes very clear that that you have to provide the services in accordance with state law. And so that would mean that your auxiliary personnel have to meet any state law requirements. So maybe you're using CMAs or medical assistants, and your state might have special requirements about medical assistants. It's very inconsistent across states. So if that's the case, make sure you're checking now what those state requirements are.
And so one of the other things that comes up is what's the difference between Incident 2 and shared visits? And this is really confusing. Shared visits, basically you can't do Incident 2 in the hospital. That's kind of another question we get a lot. You can do something called a shared visit where the NP or the physician extender and the doctor both see the patient, and you can combine those. If you're in a hospital-based setting, inpatient or outpatient, the Incident 2 benefit is basically suspended. So that's just something to keep in mind.
All right, David, when do we have to return overpayments? When does our 60-day clock start?
So the 60-day clock, the law changed a few years ago to say you have to return an overpayment within 60 days of identification. And I think there's no doubt that identification requires quantification. So it is not the first time you think you might have been overpaid. It's when you know how much you've been overpaid. And the basis for that is the requirement is you have to report and return, and you can't return an amount that you don't know. And then also there's some legislative history that the House bill would have required reporting any knowledge of an overpayment, and I think that would have applied as soon as you know you've got an overpayment, even before you know how big. Now I think quantification is what does it. So, Katie, I'm hiring a consultant. Is the work that consultant does protected under the attorney-client privilege?
So you have to do something in order to be protected under the attorney-client privilege for consultants, because the attorney-client privilege covers employees. And this is a state law issue. And unless you have a really broad state law that says employee includes an agent who might be a consultant at certain times, then you want to be thinking about the attorney-client privilege up front. And it would only work if your attorney engages that consultant up front before the work starts. So this is something to think about before you dive in to work with a consultant.
And the other important thing is that the work product privilege is only going to apply in the event of litigation. And so in the event of anticipated litigation. And so basically when you've got a consultant doing work, if it's not done in anticipation of litigation, the odds of it being protected are low.
David, does the anti-markup rule apply to the professional component of tests?
CMS says yes, and they're totally wrong on this. And the reason we know they're totally wrong on this is that the law in question, which is Section 1861 S3 of the Social Security Act, only applies to diagnostic tests. Physician services, actually I've backed up a second and just said what the anti-markup rule is, which is the basic idea of the anti-markup rule is that you can't bill more for a diagnostic test for Medicare than someone charged you. So you can't pass on and mark up the bill. So CMS says you can't pass on and mark up reads, and they say that, yes, it's true that Congress only applied the law to tests, not physician services, but that Congress's omission was, quote, inadvertent, unquote. CMS doesn't get to decide whether Congress's laws were advertent or inadvertent. So the practical thing is I would not mark up reads that you purchase. I think that's just tempting fate. But if you ever were marking it up, I wouldn't be refunding the money. So, Katie, this is one that I always have to come to you to ask. So do we have to do that fraud, waste, and abuse training that Medicare Advantage plans require? They're always coming to us and saying we got to do this training. Do we have to do that?
So the answer is that if you are a provider supplier enrolled in Medicare, there is a regulation that says you have certified that you will comply by signing your enrollment application, and that sufficiently covers our concerns about fraud, waste, and abuse training, and so you don't have to do it. And just to reassure you, the new Medicare Advantage manual language last year confirmed that. However, I would watch out if you're attesting to ACOs or health plans, etc. If you're attesting that you're doing the training, again, then you should be doing the training. Or I would say, push back first and say we don't have to because we're enrolled.
And there's a point in there that's just the watch what you attest thing. We've seen some interesting attestations. I've seen a thing from the government where they asked you to list all of the lab equipment you purchased, and then you attest that anytime you get new equipment, you'll let them know. There's no way on earth you'd do that, and you wouldn't generally have a duty to do it, but the client had been given this attestation. So be wary of attestations.
David, can we stop seeing Medicare patients altogether?
If you're not a hospital, you probably can. So, the argument someone would make is that you're discriminating based on age, but I think that that's baloney because you're not discriminating based on age. You can have a 30-year-old Medicare recipient. You're discriminating based on federal funds recipientness status. Boy, that was not English. Speaking of the Grammar Olympics. But
1-1.
If you're a physician, I think you're totally fine with that. But if you've got a provider agreement with CMS, they can terminate that provider agreement if you place restrictions that don't apply to everyone. And so that could even get to things like ambulatory surgical centers and other things that are providers, and we'll come to that in a little bit. So, Katie, I've got a RAC audit coming. How far back can a RAC audit me?
So the tool you should have in your back pocket is the RAC statement of work, which says that they can only go back 3 years from the initial determination, which is the payment of the claim. Their Medicare reopening rules do say you can go back 4 years if you have good cause. But I would push back really hard on the 3-year rule if you're talking about max. So first thing you're doing, I think you should do is just check the dates on your RAC requests to make sure they're within the 3 years. David, what is with all of these acronyms? What's the difference between a MAC, RAC, ZPIC, and a BISC?
So I had some alphabets for breakfast this morning, and these were the things that were messed up. I think that they are only technical differences. To me, this is the difference. You don't care when you got robbed whether the guy was 5'9" or 6'11". It makes no difference. So a MAC is a Medicare administrative contractor. A RAC is a recovery audit contractor. A ZPIC is a zone program integrity contractor. And my favorite, the SOUP, is the Benefit Integrity Support Center, or BISC. Only the MAC can recoup overpayment. So if the ZPIC or the RAC is looking at you, what happens is the MAC is really the one that gets the money back. The money goes to the MAC. The other people determine how much the MAC is going to recoup. But from a practical standpoint, who cares? So, Katie, I've screwed up. Which is I said so many of my sentences to Katie start that way. So, do I have to use the OIG self-disclosure protocol when it comes time to return this money?
Okay. So, first thing to know, this OIG disclosure protocol is voluntary. So, that means you don't have to use it. It's voluntary. And actually, I don't know. I've actually never advised a client to use that protocol. And David, I think have you ever advised a client to use the protocol?
Once.
It's something, it's the last place that you want to go to. So if you have a refund, you know you owe it, follow the report and return law, which says you go to the most appropriate entity, whoever paid you, and get it done there, and don't go to the OIG. The OIG is for bad and rare circumstances.
And it's funny, we see this a lot, but
Yeah.
we think it's a terrible
And take
idea.
it out of your compliance plan if it says to go to the OIG. David, what do you mean when you're talking about suppliers?
So, we're going to try and be really good in these about defining our terms. And I am increasingly becoming a word Nazi of sorts. And it's bad to use Nazi, I suppose. But in this case, it almost applies because the words you choose matter. So Medicare talks about two different sorts of entities. There are providers, and people often use provider to mean a physician or a physician assistant or a nurse practitioner. I try like the plague to avoid that. More grammar problems. So I try to avoid that like the plague because providers for Medicare are Part A entities, things like a skilled nursing facility, a nursing home, a home health administration, a rehab agency, a comprehensive outpatient rehab facility. Those things are providers under Medicare. Suppliers are Part B services, a physician, an independent diagnostic testing facility, a physical therapist who's in private practice. So a PT and a CORF, the CORF is the provider. The PT, him or herself, when in private practice, they are a supplier. The short version is providers have conditions of participation and suppliers don't. And so you may notice, like I in a letter really refrained from calling anyone a provider who is a professional. I will try to use some other term like a professional, a medical professional, a physician or non-physician practitioner, something like that. Yeah. All right, so Katie, we want to buy a scanner. And but for the economics to work, we need to take scans in from them outside, from other people. Can we take scans that are ordered in by other unaffiliated physicians?
Okay. So at the root of this question is whether you can be the physician group, or whether you have to be an IDTF in order to bill for scans ordered by outsiders. And the answer is you can perform scans ordered by outside physicians. There used to be manual language that was super confusing, and then everyone confused it more, saying that there was a limit on, or basically saying if you took this percentage of your revenue was from outside scans, then you had to be an IDTF. That's gone. And so what you need to do now is look to state law and see if there's any limits there. This is sort of related for hospitals. There's this newer guidance from CMS on whether how much you have to go through in terms of credentialing outside people who are ordering diagnostic tests and outpatient tests. And there's guidance from CMS that's pretty good that's saying you don't have to go through the whole credentialing process, and you can do sort of limited things like check their license. But I just threw that in as a side note. If you're interested in that guidance, I'm happy to send it to you. David, do we have to sign all of our charts?
Well, have to is an interesting word. So we're back to provider. If you're a provider, the conditions of participation almost certainly require it. If you are not, you're probably not required to sign the charts, but I would recommend signing the charts. If you don't, Katie has in many webinars talked about the difference between conditions of payment and conditions of participation. The short version being a condition of participation, if you break it, they can throw you out of the Medicare program. A condition of payment, as the name would suggest, is something that it takes to get paid. Generally, signature is not a condition of payment. And so you should not have to refund money due to an unsigned chart. And I know that somewhere floating around here was a question about this. which I have missed. Oh, let's see. So, well, I don't know. I don't have it handy. We will come back to that. But that's the short answer. And we've questions are pouring in. We will stick on for an extra few minutes to cover some of those because there are some really good ones. So, Katie, can one of our employees has done something bad, and this can be in either the hospital context or in the clinic context. So one of our doctors has sexually harassed somebody. Can we make them reimburse us for the damages that we incur as a result?
All right. So the answer is going to be really depend on your state law. And I think you can say pretty safely across the board that courts don't like employers going after their employees. Of course, the exception is if the employee is acting way outside the scope of their employment, which is, a fact question, I guess, to litigate. This comes up with a lot of doctor clients that we have who want to say, if this shareholder, if there's an audit because the physician didn't follow the rules, then they're going to have to pay back the money. Again, it's going to be hard to go after that person for money. And David has come up with I think, better approach is to address it up front in the compensation formula and make any expenses from audits be charged against that person through the comp formula. I think that's a good solution.
And Katie has, this is something that if you think about it ahead of time, for a relatively small, a couple of $1,000, you can, I think, deal with this on the front end.
All right, 2 midnight rule. David, when does the time start for the stay for the 2 midnight rule?
So CMS has said that the clock runs when you're receiving care. It says time in the waiting room doesn't count. So I guess the only real big question is, patient walks into, this sounds like it's a joke, patient walks into the ED, they get their EMTALA screening. Is that receiving care? And I think CMS would say no, because you're sent back to the waiting room after that. I think it's actually a little bit gray. But when you've roomed the person, I think there's a pretty decent argument that they're receiving care. But once someone's checked in, so that's when the clock starts to run, is when they're receiving care. So next 2 midnight question. So Katie, I'm a doctor. I said this patient's going to be in for a couple nights. They come in, they do really well. So the next morning, I'm sending them home. Does the hospital get to bill for that stay?
Yes, you get to bill for the inpatient stay. And actually, this is one of the circumstances that is actually addressed by the actual regulation that says that if there's an unexpected circumstance, they get better. Then it's the test is based on the admitting practitioner's expectation at the time they came in, and so if that's there, then I think you're golden. David, talking about audits again, should we buy insurance to cover audits?
I think that is not a crazy idea. I worry about insurance. I remember having a fight for a doctor group where the insurance covered arbitration about employment disputes. They were in arbitration about an employment dispute, and the insurance company said that the policy excluded arbitration. I mean, and we eventually got the coverage, but it was a giant fight. Ugh, it's frustrating. But that said, a big audit or investigation can be expensive, and so I think it is not a bad thing to have insurance for. You may, through your malpractice, maybe even most malpractice insurers have riders that can give you $25, $50, or in some cases $100,000 of defense costs already there for free. So if you get an audit or an investigation, the first question you should ask is, do I already have insurance to cover it? Because you might. And I would say many lawyers forget to tell you that you need to check that.
And it could be a lot of money.
Yeah, and actually, really, in some ways, almost any time you have a legal issue, a first question you should think is, do I have insurance for this? It's just a good thing to think, because you might. Your many errors and omissions or directors and officers policies cover stuff like that. So this is back to the 2 midnight rule, because we're kind of going willy-nilly here. So we've got an outpatient visit, let's try that again. So the doctor never signed an order. We have what is, people often call them a verbal order. I hate the term verbal order, back to my word policing, because all orders are verbal, but an oral order. We have an oral order from a person, and it is not signed. Does that mean we have to treat the person as an outpatient rather than an inpatient?
Okay. So the first question is, did you have the order at or before the time of the inpatient admission? That is the absolute requirement in the rule that you have to have. So if you had the oral order at or before the time the person was an inpatient, Then the next question is, do you have to sign it or authenticate it before the discharge? Despite a lot of discussion on this from CMS, the rule says nothing about signing before discharge. It does not talk about discharge as an end time limit. So I'm going to stick to the rule until it changes, if it changes. There's been conflicting guidance from CMS on this. In a statement on September 5th, they said that that verbal, David hates that word, orders have to be documented before discharge. But then in an open forum call on the 14th, I believe, of September, the CMS officials were saying you just had to authenticate oral orders in accordance with hospital policy. So rule doesn't say anything about it, and CMS guidance is conflicting. But the latest I know of says accordance with hospital policies. David, can the Medicare administrative contractors automatically deny the professional component if the technical is denied?
So there's a new transmittal that came out just a couple of weeks ago on this, and I've heard about it from several of you guys who have said, how come there's not more buzz about this? And I never know why there's buzz and not buzz. Probably because people don't read their transmittals. I don't know. But the transmittal suggests that the answer is yes. I think that this is a bunch of bunk because there's a principle about Medicare can't recover money if someone's without fault. So I'm a radiologist, and someone sends me a film to read, and the argument is that film shouldn't have been taken because the scan wasn't medically necessary. So clinic takes an image and sends it to me, independent outside radiologist. If that film wasn't medically necessary, I have no way of knowing that, and I think I'm without fault, and I think I get paid for that. That is inconsistent with what's in the transmittal. The transmittal suggests that if they deny the technical component, they can zap the professional component. I think that's a bunch of bunk. I think we should spend very little time on this one because it's so theoretical, but there's this new Senate bill out there about the 2 midnight rule. What's it mean, Katie?
Well, most importantly, it's a bill right now, and it's got a long way to go before it becomes a law. Think Schoolhouse rocks. So right now I'm not spending a lot of time learning about it. However, I do know that they're trying to create a separate category of short stays for people who are in observation. So it seems like it's going to be more confusing than what we have now, but we'll see what happens.
It is interesting. There are people who are really upset about the 2 midnight rule, and I do think it cuts reimbursement by making 2 nights instead of 1. But I actually think from clarity, I can't believe I'm going to say this, but it's clear. So
get it on record. David, do we have to bill the site of service consistently with all of our payers?
No. In fact, you almost can't. Some payers don't recognize provider-based billing. Medicare guidance, Medicare says that if you want to bill them as hospital-based, you have to make patients aware that it's an outpatient hospital facility, but they recognize that it may not be an outpatient hospital facility for private payers. So we're good on that one. So, Katie, an EHR question, an electronic health record. Are hospital-based physicians subject to the EHR penalty?
So the answer is no. They don't get the incentive payment, and they are also not subject to the penalty. And I can give you a cite if you're nervous about that, with CMS saying as much. Do you have to tell Medicare that, remember, I'm not subject to the penalty, I'm hospital-based physician? Actually, Medicare is trying to track that for you. However, I wouldn't trust them. And so what you can do is check your hospital-based status, and I've provided the link there so you can do that each year.
Okay, we've got more questions than you can shake a stick at here. We'll try to, and we'll go at least 5 minutes over and whip through as many of these as we can, just sort of quickly. So this is a great question. So the RAC, but it doesn't have to be a RAC. So the RACs determined, and properly, that we billed something as a new patient visit and it should have been established. They're saying I need to repay the whole amount. Is there any way I can keep or rebill the claim and get paid? Because this happened 2 years ago and I am past the timely refiling requirements. And there's no reason to focus on this one with RACs. This happens a lot, and we're seeing a lot more where payers are saying you have to refund. If your claim is off in any way, you need to send the whole thing back. And if you're past the timely filing requirement, too bad, so sad. To which I would say, to be cavalier about it, bite me. I mean, there's no basis for that whatsoever. Every case I've seen, every principle out there is an overpayment is the difference between what you were paid and what you should have been paid, and so you should be refunding the difference. And I'd fight those till the cows come home. So Let's see. Let's do another one here. Are beneficiaries liable for Part B? Katie, if you want to do this one, I'll do this one. Your stay. They had an inpatient stay, which we're now saying it should have been an outpatient stay. It should have been Part B. Do you have to charge the beneficiary? Is the beneficiary liable for the charge? Well.
David, I'm trying to come up with an answer to that.
They shouldn't wind up paying more because of it. I mean, actually, you wouldn't get off free, but the beneficiary is almost certainly without fault here. So if there's an additional payment because of they've moved to Part B status, I would not charge that to them. I don't think you need to. And so, like, if the copay is higher or something like that, I think you're fine waiving that. It is not a kickback because you're not inducing them to come. It's already happened. And so there's some talk of that, and I feel pretty good about that.
One question we're getting from a number of different clients is you want to set up these patient health record portals. I've gotten this about 6 times in the past month, and from different states. And the question is, what do we do about minor health records? Many states, the minor has access to health records, and the parent can't have access for certain visits, like sexually transmitted diseases, pregnancy, etc. And so people are saying, well, do we have to leave minor records completely out of our patient health records portal, electronic portal, or can we have them in? And what I've been saying is, if you really want the minor to participate, you don't want to have to do this carve out. You could have a minor set up his or her own account, and have the parent have their own account for their records. And you really wouldn't be, and the parent could still have access to the PHI that they're entitled to as the parent, but you could be providing that in a different way, like through paper records or electronically on a disk drive or however HIPAA permits you to do that. And I don't think you would be preserving the minors' access as well as the parents, and you wouldn't have to be worrying about carving minors out completely from your health record, because you'd still be complying with HIPAA by giving the parents access to the things that they have access to in just a different way other than the portal.
So here's a good question that we can take into all kinds of contexts. So we've got a SNF, a skilled nursing facility is billing a global fee for x-rays and lab and stuff like that. They are purchasing these services from some, like a portable x-ray supplier. And they pay the portable x-ray supplier less, what's the amount that they're paying them? And that is, there's always a potential kickback issue there. It's a question of whether the charge is reasonable or not. This is pretty common. It's the difference between Part A and Part B reimbursement and stuff like that. And there are some cases out there where they've tried to say that there's a kickback taking place. A lot of it gets to how big the discount is and what the rationale is. If there's communication between the parties that says, we'll give you a discount on your Part A stuff so we can get your Part B, you've just committed a felony. And then, so that difference in pricing is out there in the world, and it comes at some peril. Do you have another one, Katie? Because I got several more in front of me here.
David, when is this winter ever going to end?
For those of you who don't know, I'm a weather addict. It ain't ended, man. We're stuck on this one. Let's see. I got. Hang on. I just lost the one I was going to ask. All right. Oh, so can we fight a payer like Blue Cross Blue Shield who denies that claims are electronically signed or not signed at all? They're saying that they've recouped money because it's not signed. I think it depends. Do you want me to? I think the question is ultimately, what does your contract with them say? If they impose on you a requirement to sign the charts, then it's going to be tougher. If they don't have that explicit rule, then I'm not worried about it at all.
Remember to check your provider manual too.
And I would argue a signature proves nothing. I mean, here's what I'd do. I'd sign it now and send it back to them. One of the biggest overpayment cases I ever worked on was the Medicare wanted $3 million for unsigned oncology charts. And they were saying if the chart wasn't signed, how do we know the doctor was there for purposes of the Incident 2 rules? And the obvious answer is, how do you know that they were there if they signed it?
Question we get a lot is, can a nurse practitioner or a PA supervise outpatient hospital services?
You're better equipped to answer that than I.
And so this was an evolving topic, and we've settled now on non-physician practitioners who are acting within their state law scope of practice and who are acting under their hospital privileges can supervise outpatient therapeutic services. However, a physician must be the one to supervise outpatient diagnostic services. That's a really important distinction.
And how crazy is that? And I can't keep that one straight in my head, so that's why I'm really glad Katie is here. We're running low on time, but so what about employee discounts for services? So I am of two minds on this. So first, I kind of want employees to come to the place on some level. On another level, I kind of don't, because I hate when we know about an employee's health condition. All kinds of problems stem from that. I don't like waiving the copay and deductible. The insurance company might squawk. They might not, but they might. And I know it can feel bad charging the copay and deductible. What I would say is, if you charge it, you throw that money into some fund, and use the fund to have a party or do something like that is one solution to it. If the insurance company doesn't mind, you can waive the copays and deductibles. It's kind of, does the insurance company care? And in theory, they may not. But
it does seems low risk for a kickback.
It's not.
issue.
I'm not really worried about the kickback thing. It's actually, in some ways, what I worry about the most is that you get some information about a patient's health condition, and then they try to argue that somehow you've incented them to come in, and now that you have this information about them, you're going to use it to discriminate or something like that. It's either that or the insurance company squeaking for just waiver of copays. All right, we've gone over time. We have oodles of questions here. I think one of the lessons we've learned, and put this in your evaluation, I think we'll do this again.
Yeah.
I mean, so
and send questions when you do it again, even more than you did this time.
Yes. So, speaking of which, we read these evaluations.
Yes. Very
So,
carefully.
Let us know what you think, and more topic ideas.
Tell us what you're worried about.
Katie, you got anything else?
No, join us next month for joint venture healthcare, negotiating healthcare joint ventures, and then in May for physician compensation.
Oh, and I think people already know this, but remember, these slides go up on SlideShare, and so if you thought that this was worthwhile, if you're crazy enough to think that, you can send the link that it'll come out sometime next week. Forward the link to whoever you want. That they're free for a reason. So,
thanks, and survive the rest of the winter.
Enjoy Pi Day, and beware the Ides of March.